The next matter to come before the court this morning is Elizabeth McFarland versus West Congregation of Jehovah Witnesses, Lorain, Ohio, Inc. et al. Both sides will have 15 minutes to present argument this morning. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, if you let me know when you get started, I'm keeping the clock this morning to keep you advised of the passage of time. The court's read the briefs, so we are ready to see when you are.
May it please the court, my name is Robert Mitchell, together with Amanda Martinson. I represent the appellant's watchtower, the Christian congregation of Jehovah's Witnesses in the West Congregation. This matter comes before the court this morning on an appeal of an order compelling appellants to produce privileged documents. Let me summarize very briefly the facts, if I might. Ms. McFarland in this case seeks damages for sexual abuse that took place when she was a minor. The alleged abuser, who is now dead, was a fellow congregant in the Lorain West Congregation of Jehovah's Witnesses. He was not a priest, pastor, an elder, or an employee of the church. The plaintiff served wide-ranging requests for documents. The defendants produced documents and withheld some others. The documents that were withheld are set forth in a detailed privilege log. The trial court examined documents that had been withheld in camera and then entered a 2-page order on January 27th this year. At issue on appeal are 19 documents. 7 of these documents are communications between service department elders and individual congregants. One document is a letter from the elders in the Lorain West Congregation to the elders in the Lorain East Congregation, introducing and recommending spiritual care for the McFarland family, that is to say, the plaintiff's parents and her younger brother. 7 documents are letters between local elders and elders in the service department, and the remaining 4 documents are service department letters addressed to bodies of elders throughout the United States. The standard of review here is de novo, according to the Supreme Court's decisions in Ward versus Human Health Systems, Medical Individual versus Schlatter. And there are multiple reasons why these documents are privileged. Let me start with the statutory protection for cleric communications, which is found in RC 2317.02. In the part of the statute that's pertinent here, it says, the following persons shall not testify in certain respects. C1, a cleric, when the cleric remains accountable to the authority of that cleric's church, denomination, or sect concerning a confession made or any information confidentially communicated to the cleric for a religious counseling purpose in the cleric's professional capacity or character. And then it defines cleric in 2A. Cleric means a member of the clergy, rabbi, priest, Christian Science practitioner, or regularly ordained, accredited, or licensed minister of an established church, established and legally cognizable church, denomination, or sect.
I'm just going to stop you briefly right there. So assume that the communication is between clerics or that it meets the definition. The remains responsible to the organization part language. Is that defined by the purpose of the communication?
No, it speaks to the status of the cleric vis-a-vis the sect. So, for example, a cleric who had been defrocked would not qualify under the statute. A cleric who was a freelancer who got a diploma through the mail and it was not accountable to a sect such as Jehovah's Witnesses would not qualify. Someone who is and remains accountable to the denomination or sect that ordained him, that person qualifies under the statute.
But the communication itself, must it be something that the cleric is prohibited from releasing by the tenets of that person's, for lack of a better word, job with the organization?
No, Your Honor. the criteria for the communication is that the communication must be confidentially conveyed for the purpose of receiving religious counseling or providing religious counseling or confession. The language that talks about when a cleric is bound by duty never to disclose confessions, for example, comes in only in the second part of the statute, which is where there's an express consent to disclosure. And the question is whether or not, under those circumstances, the cleric may testify. And the answer is yes, unless that person is bound by the tenets of his or her church, as a Catholic priest would be, never to testify about what is received in confession. But that has no application to this case. So, if I may return to the point of the cleric, elders in the service department of Jehovah's Witnesses are appointed, and they appointed to serve as elders and clerics elders and to individual congregants throughout the country. And the elders who are appointed to serve in local congregations, those too are clerics. Indeed, the plaintiff in this case agrees. On page 11 of her brief, she says, and I quote, "There is no dispute that an elder is a cleric." Mr. Jefferson's affidavit, which is Exhibit F to defendant's memorandum in opposition to the motion to compel, which is uncontroverted, explains how these elders remain accountable to their sect, that is, Jehovah's Witnesses. He explains the responsibilities of both the service department elders and the local elders. The service department, which is located in Patterson, New York, has the responsibility, among other things, of providing to the elders spiritual advice, counsel, and guidance, to the local elders and to individual congregants who call or write seeking such guidance. Local elders are appointed to provide spiritual and religious oversight on a local level. They are accountable to, and they receive instruction from, the elders in the service department. As Mr. Jefferson's affidavit explains, all of the communications at issue here were made in confidence and in the expectation that they would remain confidential. There is no contention, nor can there be, that any person making these communications has expressly consented to disclosure. Now it follows from those uncontroverted facts that those communications are protected by the statutory privilege. This is obviously true of the letters and phone calls between individual congregants and the service department elders. There are 7 such letters and phone calls. Document numbers 183, 184, 185, 186, 187, 196, and 197. It's also true of the letters between local elders and the service department elders. Those are document numbers 188, 189, 190, 191, 193, 194, and 195. The service department elders provide religious counseling to the local elders. And it's true as well of the letter between one group of local elders and another. That's document 192. There, the elders serving in the West congregation were writing to the elders in the East congregation to share, confidentially, information for a religious counseling purpose. Finally, we believe that the statutory privilege protects the 4 body of elders' letters, 17, 21, 30, and 55, because they provided confidential information to the local elders for a religious counseling purpose in the cleric's professional character. That's what the statute provides. The statutory privileges in RC 2317 are very carefully drafted. They've been revised over time and expanded. The Ohio Supreme Court, as it said in Jackson versus Grieger, and I quote, has consistently rejected the adoption of judicially created waivers, exceptions, and limitations for testimonial privilege in statutes. Close quote. And as the same court held in Roe versus Planned Parenthood, redaction of personal information does not divest the privileged status of confidential records. Redaction is merely a tool that the court may use to safeguard the personal identifying information within confidential records that have become subject to disclosure either by waiver or by an exception. These documents, of course, are not falling into that category. They are privileged in toto. I want to focus now on the constitutional dimension of this discovery dispute. As the Ohio Supreme Court made clear in Humphrey v. Lane, 89 Ohio 2nd, 3rd, 62, Article 1, Section 1.07 of the Ohio Constitution requires that a generally applicable, facially neutral requirement that allegedly infringes or burdens a party's right to free expression or free exercise of religion must be judged by the standard of whether it is the least restrictive means to further a compelling state interest. In applying this standard, the court held, the first step is to examine the beliefs of the person who's affected by the regulation to determine whether they are truly held, and then whether the government's actions have a coercive effect against him in the practice of his religion. Again, we have come back to Mr. Jefferson's affidavit, which is undisputed. Mr. Jefferson's affidavit explains that, quote, confidentiality of spiritual and religious communications between members of the congregation and elders is a foundational element of the religious beliefs and practices of Jehovah's Witnesses. That's paragraph 12 of his affidavit. It goes on to say that if an elder from a local congregation or the service department was compelled to disclose confidential information, his credibility and effectiveness as an elder, as well as the credibility and effectiveness of other elders, would be adversely affected and compromised. That's in paragraph 13. And this stands entirely to reason. Congregants who lacked confidence that what they said to elders would be held in confidence would be reluctant to share private and embarrassing information. And as a result, they would not disclose matters that are vital to their spiritual and their temporal well-being. And so the question becomes this: is the compelled disclosure of confidential communications between elders and congregants the least restrictive means to further a compelling state interest? Of course it is not, particularly where Ohio law itself recognizes the vital interest in protecting such communications from disclosure in court proceedings such as this. For these reasons, the order of the trial court should be reversed insofar as it requires the production of these 19 documents. And the matter should be remanded with instructions to safeguard those documents from compelled disclosure. Does the court have any questions?
Seeing none.
I'll reserve my remaining time then. Thank you.
Good morning. May it please the court. My name is Statutory, and I represent McFarland, the plaintiff and Appellee. Looking first at the clergy management privilege in this case. The key language here is exactly what was referenced by Judge Hensel, that the cleric must remain accountable to that cleric's church, denomination, or sect concerning the confidentiality of the statement made. Now, the Jehovah's Witnesses offer an explanation. And they say, well, that language, accountable, means that the person has to remain a clergy member for the privilege to apply. But if you take that a step further, you'll see that it doesn't make a whole lot of sense. Effectively, for instance, if a person went to a Jehovah's Witness elder and made a confession that would unequivocally qualify for the privilege at the time it was made, only through no fault of the communicant, to have the elder subsequently cast out or removed from his position, the communicant would lose the protection afforded by the privilege. That's not a reasonable interpretation of the language accountable to the denomination. And regardless, the Jehovah's Witnesses have made no showing that the elders who receive those communications remain elders to this day. So by their own logic, they haven't made the showing necessary to preserve the privilege. A more reasonable interpretation of the word accountable to the congregation or accountable to the denomination comes by simply giving accountable its plain and customary definition. And subject to, or looking at the Merriam-Webster's dictionary, It means answerable. Is the cleric answerable to his denomination concerning the confidentiality of those statements? And the evidence that we've presented is no. Under the Jehovah's Witness construct, an elder is not answerable. The testimony that we've presented through a corporate witness of the Watchtower under oath subject to cross-examination is that that elder gets to make the decision what he does. Not all communications to an elder regarding child and sexual abuse are even considered confidential, but to the extent that one is made, the elder has the discretion to go to the authorities and make a report with no potential censure from the organization. And even if the communicant doesn't want him to, that's not an individual who's accountable to the denomination.
Well, if my religious tenet is that you must make reconciliation or confession, but the church in and of itself would not censure me if I went and disclosed that communication. That would be the situation that you say we have here, right?
So to be clear, under the religious tenets of the organization, the communicant believes that part of the religious practice is to make confession, go to an elder, go to some kind of a cleric, and the cleric can do whatever they want with the information.
Right, that's the situation.
And frankly, that is the situation. And the answer to that is that cleric doesn't remain accountable to the organization regarding the confidentiality of that statement. So it's not going to meet the language of the statute, and it's not going to qualify for privilege.
Well, that probably brings us then to the constitutional argument. And maybe we're fast forwarding too far, but that's where it brought my mind to regarding the chilling effect of these communications and the practice of this religion. So you're saying, correct me if I'm wrong, that it may not be the best case scenario, but if they choose to allow their clerics to disclose this information.
And one point that I may have neglected to mention is that this policy, in the testimony that suggests that a particular communication is not kept in confidence, is limited. That was discussing only complaints of child and sexual abuse. That's not saying that you could never, in any circumstance, have a communication with an elder that would be confidential. But in that particular context, the statement would not qualify.
And when we are able to review the record, it will be clear to us that those communications which were ordered to be disclosed were specifically related to abuse of minors, sexual abuse of minors?
To some extent, Your Honor, I can't tell you. I thought you
right, wrong question.
I thought you had seen the documents. I thought I was the only one who had. But what
this
I can
is
tell
the
you,
wrong person to ask this question, and I apologize.
What I can tell you is that the judge, the trial court judge, looked at several documents. He looked at 197 documents, and some of those dealt with Scott Salesi, the molester in this case in particular. And the court made a determination that some of those documents were not quoted. And specifically, in his order of January 27th, made a finding that, I can't tell if some of these documents deal with a minor. If they deal with a minor, they need to be produced. If they don't deal with a minor, they don't need to be produced. So my expectation is that, yes, if he ordered these documents produced, they deal with the sexual abuse of a minor. And from the argument that we just heard, I suspect that at least some portion of them deal with specifically the sexual abuse of my client. So I think that will be very clear when you do look at the documents.
If some of them, in fact, dealt with sexual abuse of a different minor, how would those be relevant in this case?
Well, it could be relevant in a number of ways. Initially, we have no way of knowing if that different minor was abused at an earlier point in time than my client. And if that were the case, and there were some type of a complaint, that could be very important to the issue of establishing negligence. Therefore, knowledge of the risk posed by Salesi and their inability to do anything to protect my client. So that information, it can also corroborate the extent to which Salesi was, in fact, a molester, making corroborate my client's testimony through establishing that someone else had similar experiences with this particular man. So there are a number of ways that documents evidencing sexual abuse of someone else would be very relevant to this case.
Ben, could you speak to, I believe you have briefed that the standard of review is abuse of discretion.
Yes, Your Honor. And we've taken a look at the cases cited by the defendant, Ward and Bed Mutual. And even subsequent to that, there have been cases in Ohio that have found that in some circumstances, an abuse of discretion standard is appropriate. And that would be when you're dealing with some kind of a factual determination. So, in this case, we take a step back. In Ward, you had a circumstance where there was a pure issue of statutory construction. You had a doctor who was trying to apply physician-patient privilege to his own medical condition. And does that circumstance, as a matter of statutory construction, fall within the privilege? So there was no factual issue. There was no review of any particular documents. In Bed Mutual, you had a determination of contract language. Also, it's a de novo issue. It's a question of law rather than a question of fact. In this case, you have a circumstance where the judge took these documents, he looked at them in camera, he went through 197 documents, looked at each one and determined, do the facts, does this document qualify for the privilege by looking specifically at the facts. So we would argue this is a factual issue that would be subject to an abuse of discretion standard. And ultimately, both Ward and Bed Mutual derived from a case called Castleberg versus Dignity Properties Liability. And in Castleberg, the court noted that the abuse of discretion standard should be used when the trial court makes discretionary decisions based on such things, for example, as evaluating the credibility of witnesses, which we have here. We have a declaration of Thomas Jefferson, and we have contradicting testimony in many places from Mario Moreno as the corporate witness of the defendant. Also, for ruling on the admission of evidence. And while this is not the admission of evidence, this is the production of evidence, it does carry a certain parallel. So we believe that the court should look at this particular issue with the use of discretion standard in mind. And before I start my low on time, I would like to briefly address the First Amendment. They've made three separate First Amendment arguments. They've made a federal free exercise argument, and we've cited Employment Division versus Smith as the seminal case dealing with that issue. And the defendant has contended that that case was overruled by the federal RFRA statute in 1993. And what they don't tell you is that RFRA was found to be unconstitutional in 1997 by City of Bernie versus Flores. And that was something that's been recognized by the courts of this state in State versus Blackman, and it was also referenced in Humphrey versus Lane. So, free exercise claim, it's an issue of this is a general law of neutral applicability, and it's therefore applicable with no First Amendment issues. Next, they make a state free exercise claim. And with respect to the state claim, it's a three-part test. They have the burden on the first two parts. They have to establish that the person who is going to be impacted by the governmental action has a sincerely held religious belief. That religious belief would be coercively affected by the state action. And then the burden shifts, if they make both of those showings, to the plaintiff to show that the state has a compelling interest and that this governmental action was narrowly tailored. So looking first at the issue of who has the, looking first at the issue of whether there's a sincerely held religious belief. The defendants, they don't make any showing as to what the individual communicants' beliefs were. The argument that they're making is that, well, Jehovah's Witnesses generally have this belief in communicating with elders confidentially. So the person who would be impacted by the production of these documents is not the defendants in this case, it's the individuals who communicated with their elders. But they've made no showing as to who those individuals are. They provided no affidavit from any of those people indicating that they are Jehovah's Witnesses. We know that Solesi has molested at least one child who wasn't. And they've made no showing of what those individuals believe. So they have failed in their obligation of showing that the individuals to be affected by the order held any sincerely held religious belief. Now, secondarily, they make an argument as to the second prong that there would be a chilling effect on people coming forward and speaking with elders if, in fact, these documents were produced. And it fails for the same reason. First, they have nothing from the individuals who actually made the communications, indicating that this would somehow prevent them from coming forward in the future. But secondarily, it just doesn't stand up to the record. There have been, first and foremost, I'll go back to the example of a molester who's making a confession to an elder. Under the rules of the Jehovah's Witnesses, if that individual goes to an elder and says, "I molested a child," he knows that the elder has the possibility of going and making a report to the police, even if he doesn't want him to. So if there's going to be something that's going to prevent this type of communication, it's the threat of criminal prosecution, not the fact that the documents may be turned over in a subsequent lawsuit.
What about if one group of elders is assisting in counseling another group of elders on this issue of the sexual molestation of the minor? What about that desire to have those things kept violently secret?
Again, we would need to be looking at the underlying desire of the individual communicant in that circumstance. And there's no evidence that any of these people who communicated with the defendants had that suggestion. In fact, in large measure, I would venture that the vast majority of people who are communicating with an elder about molestation of a child were probably a victim of the abuse or are making a report of some sort and are looking for some kind of action to be taken against the molester.
Well, right, but the question was the internal church communication between various elders, for lack of a better word, a different one. If they believe that there is something they wish to address within their organization, but they do not believe that that will be kept, that communication will be kept secret, does that not have a chilling effect not on the declarant itself, but on the operation of their established?
Can I restate the question to make sure I understand? So,
Please do.
Effectively, what I'm interpreting is you have two groups of elders. You have one group of elders with information about child molestation, and that group decides they're going to reach out to the second group of elders to try to figure out how to handle the situation.
Correct.
And you're asking if that type of a circumstance was not privileged, would it have a chilling effect on Group A from reaching out to Group B for advice?
Okay.
I was with you until right at the end.
You're still with me. We'll answer that question.
Okay. Well, in terms of whether there would be a chilling effect, there's certainly no evidence to that. There's nothing to suggest that there would be. And for instance, in the declaration of demonstration, in the record filed with the opposition to the defendant's motion for protective order, there are a number of exhibits that are attached. There are letters from individual molestation cases that have been filed publicly over the last 8 to 10 years. There has been litigation on this issue. Documents have been ordered and produced. And despite that, there's no evidence in this record that the production of these documents has had any chilling effect. Second.
Thank you, Counsel. I regretfully need to inform you that you've reached the end of the 15 minutes. Thank you for indulging the questions.
Thank you, Your Honor.
Counsel, you have just under 3 minutes remaining.
Thank you, Your Honor. First, I'd like to clear up a question or two about the application of the statutory privilege. The counsel made the point that our interpretation would require evidence that the elders who received confessions or had counseling done 10 years ago are still elders. That's not the issue. The question is when they received the communications, whether they were accountable to the church. And in this case, there's no question that they were. Secondly, he says that communications may qualify, but not if they are basically admissions of child abuse because of the permission that elders have to disclose those things. All of the communications at issue in these 19 documents followed the disclosure of the abuse in this case and the investigation of that abuse by the authorities. The most recent of them dates from September of 2014, which of course is more than a decade after the fact. And so by the plaintiff's own admission, such communications should be protected because they are not disclosures of child abuse of a minor, or child abuse that could be disclosed to the authorities. In addition, in this case, there's a reference to a prior minor who was abused by the same gentleman. That prior abuser was disclosed in, that act of abuse was disclosed in the answer, and the prior victim has been already deposed in this case. Finally, on the question of the standard of review, for three reasons, Your Honor, this court needs to apply de novo standard of review. First, of course, is because the Ohio Supreme Court says so, that when privilege is at issue, that's the appropriate standard. Second, because there was no credibility determination made by the trial court in this case. The trial court was looking at documents and trying to apply the law to it. This court stands in exactly the same position as it would in a summary judgment proceeding. And third, because the trial court heard from the plaintiff below that this statutory privilege applies only in cases of confession. The plaintiff was citing an earlier version of the statute in cases construing that statute as was previously written. And as far as we know, the court misapplied the statute because they were misinformed about what it required. This court knows the law, can apply the law to these documents, and should do so. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties as well as posted on the Ohio Supreme Court website, which can be linked to the 9th District website. Thank you.
Thank you.